So just a quick introduction. My name is Charlie Weisinger. I am a board certified estate planning attorney. What that means is I've done at least 2 or 3 of these before. I've been practicing for about 10 years, almost exclusively in estate planning, probate, and guardianship in those 3 areas. And then I've gone on to become board certified in that. Our office, that is pretty much exclusively all we handle. We spend probably 90% of our time in either estate planning, either doing estate planning, where we're writing wills and trusts, or helping people through the probate or guardianship process. Beyond that, we have 2 attorneys in the office that do a couple of other things outside of that. We do some business planning, so LLC creation, and we do some real estate work. So if you have anybody that has a dispute issue, you can talk to somebody in our office. So why estate planning, probate, and guardianship for realtors? Why did I start teaching this course? Well, early in my career, I had several phone calls from realtors who had got a contract on a property and were ready to go to closing, and the title company called them up and said, "Hey, we can't close this until you show us letters testamentary." And the realtor said, of course, "Well, what the heck is letters testamentary, and why do I need it?" "Well, it's what you get when you probate the will, so you need to go ahead and have the will probated." And so the realtor would call me up and said, "Closing is scheduled for Friday. Today's Tuesday. Is there any way we can get probate done by Friday so that we can get this house sold?" And I had several very sad realtors find out that no, we could not sell the probate done in 2 or 3 days. That in fact, it was going to take 2 or 3 weeks at the fastest if we were able to do everything. I had some very sad realtors find out that their client wasn't the person who was ever going to have authority to sell the house or inherit it. And so I thought, is there a way I can teach a class to realtors to keep you guys from wasting your time and effort, find out early if there's going to be some title issues, or at least know what to look for, know what you should be seeing, so that you don't get stuck spending all of your time selling a property, marketing it, getting a buyer in place, and then find out you can't close the deal. So that's, in a nutshell, why I started. Course objective here is to assist you guys in selling homes when we're dealing with somebody who has incapacity or has passed away, and then also to help inform you and your clients on ways to protect your investments there. So we're going to cover things like what happens when the owner of the property isn't the person talking to you, who can act on behalf of that owner, and then what happens if that owner passes away in the middle of the transaction. All right, so we'll start with just basically what is an estate plan. An estate plan is not for the extremely rich. It's not for the wealthy. I had a one time a good friend of mine lived in Hill Country Village, was a doctor, and he said, "Well, someday when I have an estate, I'll go and see an estate plan." I thought, okay, you're much more successful than I am already, and I have one. And what I realized is there's a stigma around estate, the word estate. Everybody thinks, well, my estate is this dream, something I aspire to someday. Well, it's not true. Our estate is just simply what we own, everything we own right now, and what the stuff that's going to happen when we pass away. So an estate plan is simply a plan that provides for your assets, or handles your assets and provides for your loved ones upon your death. And in the case of disability or total incapacity, it's the plan that provides for your well-being while you're alive. So why do we care? Why do we need the plan? Well, if you have children, you want to make sure they're taken care of. You want to make sure that they're taken care of by who you choose instead of who the grumpy judge downtown chooses. We want to make sure that your assets go to who you want them to, rather than what I see a lot of times. I see clients that come in and they want to contest the will, or they want to fight things out, and I say, okay, is it more important to you that your brother on the other side gets nothing, or that you get something? Because if you want to fight it out, your brother, we can pretty much guarantee your brother's not going to get anything, but if he doesn't get anything, neither do you, because it's all going to go to the rich lawyers, that are sitting in the room fighting back and forth. Because if you've ever been in any litigation, hourly rates. It doesn't matter if your attorney's charging $200 or $500 an hour. They can figure out how to charge a whole lot of money and bankrupt an estate. And so unless this estate's worth millions, most of the time, it's not worth litigating. And so we can lose a lot of, your clients can lose a lot of money paying lawyers for what we call in our practice the litigators, those guys that we don't like to deal with. And so we do our best to try to keep people out of that here. Okay. You also want to plan for your health and your life. You want to choose that if you're in certain conditions, how do you want to be taken care of? Do you want, if you're incapacitated, do you want to be kept alive using life-sustaining treatment, or do you just want to be allowed to die gently and go home? And so here are the important documents. This is not the full list of documents that we do, but this is really the 7 basic documents that you'll see every estate plan. We're going to talk through most of these today. So we'll go ahead and start with your durable power of attorney. How many of you have used a durable power of attorney in the past? Okay, several hands. Tell me a reason that you used one.
I used one for my mom who was unable to travel and had property in Florida to sell. And so I went to Florida to sell those properties and had to have that power of attorney. But I have a question that we'll get to that.
Okay, so you used it to sell property
Yes.
on behalf of your mom, who was at that point, was she incapacitated or just couldn't make it back?
She didn't want anything to do with it.
She
She
didn't want
just wanted it taken care of.
Good, okay, perfect. Anybody else used it for any different reasons?
Buy property and cars when my husband's deployed military.
Yeah, perfect example. What she said was buying property or cars while her husband was deployed. So durable power of attorney comes in handy for all those things. Can be used for signing checks, entering into contracts, dealing with creditors, things like that. Why are we talking about it in here? Well, what are some of the things that you guys need to be looking for when you're presented with a power of attorney? If somebody says, oh, I'm going to sell my mom's house, here's the power of attorney that gives me the authority to do that. Well, a couple of things. What are the title companies going to look at? They're going to look at, first, when was it signed? If it was signed 15 years ago, title company's probably going to have a few questions. How do we know that they're going to consider it stale? Because they're going to say, how do we know this person didn't revoke this power of attorney in the last 15 years? We would like something a little more current. But current can also be a bad problem. What if it was signed yesterday? Well, the title company is immediately going to have some questions. Jeff, why did they sign this power of attorney yesterday? Where is mom today? Well, if his answer is, well, mom has dementia, then really just today? That's called rapid onset. It just happened. So if mom could sign the document yesterday, then she should be able to sign today. We shouldn't need to use power of attorney. That doesn't always mean that it's stupidly out of. What if it's the scenario where we were talking about, husband gets deployed? Well, power of attorney, it's an emergency deployment, power of attorney is in place. That document could be good if there's a good reason for using the power of attorney. If you're planning to use power of attorney in a transaction because somebody has traveled, the first thing you need to do with the power of attorney is send it to the title company, because they're going to tell you either A, this power of attorney is perfect, and these are the things we're going to need from you, or B, this power of attorney is horrible, you need to do something different. Or, they can tell you some things. If it's a planned absence or a reason, they're probably going to ask you to do a special power of attorney for that specific transaction, rather than having this general power of attorney. They're going to want to say, oh, mom's traveling out of the country, somebody else needs to close this, we're going to have a power of attorney that gives you the authority to do nothing other than close this transaction. And so that can be really good. Yes, ma'am.
Something I've learned to look for, certainly does it work for real estate, but is it complete? I had within a month of each other transactions with children having a power of attorney from the parent, and it was notarized, but only at the end, not in other places that it needed to be notarized, mainly initials. Both kids said, no, my mom did that at the attorney's office. So I was kind of disappointed with that attorney that their notaries didn't know what to notarize.
Yes, there can be lots of problems with those powers of attorney. And my next question on the slide is, was the document prepared by an attorney? That's not always fail-proof, but it helps a whole lot. I'll give you a good example. This last year, and I didn't introduce Jeff. Jeff's another attorney in my office, and he's the reason I'm here. He introduced us today. But he and I had a client together that was, we'll call him Mr. Smith. Mr. Smith, we actually went over to his home, met with him there, and executed powers of attorney in his home. He did have he was in the early stages of Alzheimer's at that time. Okay. 6 months later, or fast forward about 6 or 8 months later, mom and dad need to sell, or the kids figure out they need to move mom and dad into an assisted living facility. He had taken a rapid decline, and now we need to sell the home. And so they present the power of attorney that was prepared in our office to the title company. And the title company says, well, we need proof of Mr. Smith's disability. And so they give the medical records that show Mr. Smith had a disability. Of course, the medical records show that the onset of Alzheimer's was before the date of this power of attorney. So what does that, had we not done this in a lawyer's office, had they gone on US Legal Forms or LegalZoom or gone down to the UPS store somewhere and gotten the document notarized, the company would have kicked it out and said, no, we're not accepting it. But because it was prepared in an attorney's office, they were able to call our office and say, Mr. Weisinger, we see that you prepared this power of attorney with Mr. Smith. Can you confirm that you talked to Mr. Smith, that he had capacity at the time that he signed this document and was able, and would you sign an affidavit to that effect? And I said, of course we would. We'd love to. And so because of that, we were able to get that transaction through, and they were able to sell that home. Without it, they would have had to go through guardianship or community administration. It would have been a big headache for the family. When the powers of attorney fail, it can be a big headache. So having it prepared by an attorney, and specifically an attorney or law firm who focuses their practice in this area. I tell people all the time, you've got to choose specialists. You've got to choose people who work in a certain area, because if you don't, you're going to make mistakes. If any of you ever get arrested for something, do not call me, because I don't care if it's just a misdemeanor. You'll spend a lot of time in jail while I try to figure out what it's just not my area. I've never done it, and I'd be terrible at it. A good criminal defense attorney will tell you, don't ever ask me to do it, Will, because I don't have a clue what I'm doing. So make sure that you know what you're doing. So I hand over here. Yes.
Yeah, in the case of Mr. and Mrs. Smith, Mr. Smith is in downside. Mrs. Smith doesn't have the power to sell the house on her own.
Good question. So her question, for everybody that couldn't hear it, is Mr. and Mrs. Smith, they're on the house together. They're both entitled. Can she just, now that he's declined, can she just sell the house without him signing on?
She's gonna have the power of attorney too.
Well, she would also have to have power of attorney. So no, just because you're both own a house. In Texas, we own property most of the time as tenants in common. And so that means we both own a 50% interest in that house. Without having power of attorney for your spouse, you cannot sign on their behalf of the real estate closing. Yes, ma'am.
Once somebody who's given power of attorney passes, that power of attorney dies with it, right?
Correct.
Because then it becomes a state will probate and all that.
Yeah, so power of attorney is the document that can be in power during the lifetime, but as soon as the person passes away, the power of attorney expires. Any other questions on the durable power of attorney? Yes.
I'm curious, for a single parent, if they pass away without something like this, does it go to the next of kin, their adult child, or it has to be everything documented?
We will cover that. We'll cover that when we get to probate.
Okay.
Which is here in a little while. That's kind of in the middle of the class. We'll cover all those issues. Okay. Anything else on the power of attorney? Next, we're going to talk about the medical power of attorney. And you may be thinking, why are we talking about a medical power of attorney? This is a real estate class. Well, Again, early in my career, I had several people very upset because they said, I'm mom's power of attorney. And this title company, they're being jerks. They won't accept the power of attorney. They won't let me close this transaction. I need you to call over there and tell them that I have power of attorney. And I said, okay, well, bring the power of attorney. Let me see what the problem is. And they put power of attorney in front of me. I don't have to read anything past the title because at the top it says medical power of attorney. And I realized very quickly, okay, we're dealing with a medical power of attorney. Another name for it is the durable power of attorney for healthcare, which is somewhat confusing. That's why we refer to it as a medical power of attorney. This authorizes the person to make medical decisions. Where it gets confusing and where this client was tripped up was it says that includes treatment decisions as well as placement decisions such as nursing care or assisted living. It says I have the right to move my mom into an assisted living facility, and the only way I can move her into an assisted living facility is if I sell her home. And so I said, well, that doesn't work. Do you happen to have any other documents? Do you have another power of attorney? And so we looked through it. They had a regular durable power of attorney, we might have been able to do that, but instead we have to go through what's called the guardianship process at that point. So, moral of this story for you guys is if somebody presents you with a power of attorney, read the document. And then if you don't want to be the bad guy that tells them, don't think this is going to work, send it over to the title company. They'll be happy to be the bad guy for you. And then you can send them to us. We also don't mind explaining the process of how they're going to get through this situation. But the medical power of attorney will not allow them to sell the home.
I got a question. Going with that placement decision about selling the house. We were having this discussion about 2-3 weeks ago. Does it have to be sold like about a certain amount of years, like 5 years before they move to a nursing home, or can they sell
on
it
what
from
they're
one
going
year to the
What's
next?
the look back?
Yeah.
Yeah, so you're talking about for Medicaid issues.
Yes.
Yeah,
and look back
Medicaid, it's 5
periods
years
and
for
5
Medicaid.
So selling the house, so you can keep the house and qualify for Medicaid if it's the homestead, as long as there's an intent to return. And so if they're going into a nursing home, but we think they're going to have some type of ability potentially to return, then you can keep the house without selling it Medicaid. If there's a spouse living, then the spouse can remain in that home, and not be disqualified for Medicaid purposes. Upon death, they may be subject to the Medicaid estate recovery program. And so where the 5-year look back period comes into play is you can't give away property. So she couldn't sell the house and then gift that money to her child and then apply for Medicaid. And she couldn't give the house to a child and apply for Medicaid. That's a whole other topic that we could spend an hour or two just talking about the different Medicaid issues and ways to get around some of that, or ways to work through those programs if we have a situation where we need to protect the house from Medicaid.
I'll just give them one of your business cards next time.
Medicaid's different from other programs too.
Yes, well, Medicaid is, they're linked, Social Security and Medicaid are linked in Texas, so if you qualify for Medicaid, you're gonna get Social Security and vice versa, but yeah, whole other.
Yeah, but there's other programs.
Okay. Next document on our list is the HIPAA release, okay? HIPAA release stands for the Health Insurance Portability and Accountability Act. Remember, that'll be on the test later. And then what this document does is allows you to name who you want to get access to your medical information. This is very important to have in those cases, like when I was talking about the situation with Mr. Smith earlier. Mr. Smith's, he's not able to sign documents, and the title company wants some proof that he's incapacitated. Well, if we don't have a HIPAA release, the doctors aren't going to release the information to us to prove his incapacity. So having that HIPAA release that says, I want my 3 children to have access to my medical records if I'm not able to give that release in the future, they have that. And so that's why this form is very important to your clients. Okay. Next document on that list is the Declaration of Guardian. This one is simply a document that allows you to pre-elect who you want to be your guardian in the case of total incapacity or long-term incapacity for some issues. So think things like dementia or traumatic brain injuries, or even of a child who's had a disability from birth and now he's turning 18, and if he had some property or things that we might need guardianship to step in. My favorite part of the declaration of guardian form is this last line down here. You can also disqualify certain persons from ever serving as your guardian. So you can say, like in my case, my older brother Wayne, I want to make sure that Wayne is never, ever my guardian. because Wayne, and he'll tell you, he was the favorite, and then I was born. Ever since then, he's been trying to get rid of me. I've been in charge of of anything that has to do with keeping me alive. And so I can write on that form, please disqualify Wayne from ever doing that.
Is this in lieu of a POA?
Good question. So our question is this in lieu of a POA? It can, we use it as a backup form. So we want to still have the powers of attorney in place because we hope those work and that we never ever need guardianship. But if we have that issue come up where all of a sudden we needed, the bank or title company somewhere looks at it and says, this power of attorney is no good, we're not accepting it. And so we're forced to go through court to either, we have two choices. We can go to court and ask the court to force somebody to take it, to accept it, or we can go through court and have guardianship put in place because we know, which was probably the way we're going to go most of the time, because if we force this title company to accept it, that doesn't mean the next bank is going to accept it too, and we may be going back to court multiple times. Guardianship would override powers of attorney. So we do this form for two reasons. One is to back up in case power of attorney fails for some reason, and two is to put it in place in case somebody challenges the power of attorney. So you say, I picked Jeff to be my power of attorney, but my brother Wayne says, no, I want to be in charge. So Wayne files for guardianship. I would say no. The court would look at it and say no. While Charlie had capacity, he named Jeff to be the power of attorney. And in addition to that, if guardianship was ever needed, he also said Jeff should be the guardian. So it's just kind of a good backup form to that. Yes, ma'am.
So they're done at the same time?
We do these two things at the same time. Yes.
So in the case of guardianship, so if you have two children and you don't want to offend one because you selected the other, how do you deal with that? Can they both be responsible or do you have to select one?
Good question. So can you put co-guardians down? I'm gonna answer this for co-guardians, co-agents under powers of attorney, everything. In some circumstances, yes, you can. So co-powers of attorney, you can do. Co-medical powers of attorney, you can do. It's always a bad idea to do it for a couple of reasons. One, banks hate it, and so they're going to make your life miserable, and having everybody come in and have to sign everything together, and any changes need to be made. It can really slow down the process. Co-medical power of attorney, we'll do that sometimes if we think kids get along really well and they all respect mom and dad's wishes. Then I won't have that big of a problem with that. On guardianship, however, the court will typically only pick one person to serve as the guardian, so we're going to have to choose there. The only time that they will allow co-guardians is when it's a married couple. So husband and wife getting guardianship over their child, or husband and wife getting guardianship over one of their parents because they maybe husband's a stay-at-home and he has more time to take care of parents than wife does. That kind of thing can be different issues. So that question comes up a lot. People don't want to offend people, and I always tell them you should tell the person that you chose they're the ones that should be offended because you just gave them a whole lot of work to do.
Exactly.
So, but people feel it's a great honor to do this, and really you just have to choose what's most practical and what's best for you. And that goes for, especially if we're talking about the other guardianship document, taking care of who's going to take care of my children. Well, making no choice is the worst thing you can do because you're just, you want to talk about people being offended, don't make a choice and leave it up to them to find it out in court. That can be where it really struggles. So run the risk of offending somebody. Now you can split jobs. You can say, I'm going to put this person in charge of finances and this person in charge of medical. You can do that if you've got issues that way. Maybe that helps. you feel better about it.
Or they work against each other.
Yeah, I mean, there, you do run that issue of
Yeah.
the person that wants to get the best medical care and the other kid says, well, I can't afford it, or won't release the money. And so again, if you're going to have several, you need people that work really well together. Another choice is don't pick either of the two kids to do some of these things. When it comes to the money, you can always pick financial institutions like Jefferson Bank or Frost or Broadway. You can pick one of those folks out there. There are for the medical, or you're gonna have to find somebody you're working from.
Just because they're the oldest child doesn't mean they're the right child.
Correct,
You know?
yes. I use the example, so I have 4 boys. My oldest is 5 right now, and I've already seen an example of why he may not be the best choice for executive. He's a great kid, but if I ask him to pass out candy or snacks to the kids, he says, okay, 1 for you, 1 for me, 1 for you, 1 for me, 1 for you, 1 for me. He always ends up with 3 times as much as everybody else. So I think, okay, well, he's gonna have a lot of growth before he ever gets put into that. So he's only 5, but we have a lot of time to work on it. So,
An entrepreneur.
okay. Guardianship. Have any of you been through the guardianship procedure or have any familiarity with that? Okay. Who is guardianship for?
It's for my son.
Your son, okay. And how old is he?
He is 24,
24? Okay.
and so it's one of these things where, as you said on one of the pages, it will be a permanent situation.
Okay.
So I'm just trying to figure out why I have to keep going to the dadgum courthouse every year.
Yes.
That I don't like. I don't.
Yeah.
I'm his mom, and I'm gonna always be his mom. Do y'all
So
do that
that's-
when you
yeah, so
end that
that's-
mess?
Unfortunately, that's the world of guardianship.
So everybody has to do
Yeah,
that?
so you bring up some really good points, and we're gonna cover a little bit about the guardianship process here, just to see. And when you have a child who turns 18 and has never had the capacity to sign documents and to do these things, there's really not a way to get around that. But if you're an adult, having power of attorney in place, having these documents in place can help us avoid those processes. So I'll give you a story about from my personal life. My brother Wayne, that I talked about earlier. You remember I mentioned I'm the younger brother, right? So that means that even though I'm an estate planning attorney and I do powers of attorney for everybody all the time, it means he and his wife had not come to see me. They had not done things right because I'm the younger brother. Well, about 5 years ago, he was in a major car accident. He was driving his Corvette down 281, got hit by an SUV and was airlifted to University Hospital, spent about 3 weeks fully in a comatose state, about 3 more weeks there at university, then transferred over to the VA hospital, was in the VA hospital for about 3 weeks, and then went to a rehab facility for another 2 months or so. Okay. So in that process, now, my brother and his wife, this was a later marriage for them. They'd only been married a few years, and so they did not have any joint bank accounts, and everything was separate there. They had, they were not named on each other's bank accounts or anything there, and like most Americans, they live paycheck to paycheck. And so this accident was about 2 days before rent was due, and it was his job to pay the rent. And she covered some other expenses and things. And so after the initial shock of, him being in the hospital, we've been there about a week, she comes to me and says, I need to get access to his money, to do things. And so I said, well, try to go to the bank. Maybe he named you on something. And of course, she got down there and figured out that she was not named on any of his bank accounts. And so she said she went in to talk to the bank manager, says, I need to get access to money. We need to pay the rent. He's in the hospital. She says, the bank manager says, sorry, I feel really bad for you. However, your name is not on any of these accounts. I cannot legally release any money to you. So she leaves there and she says, okay, well, I think I have enough to maybe cover the rent, but I'm gonna have to start cutting some expenses real quickly. So she calls up his cell phone company and says, tries to reduce the plan bill. I'm sorry, Ms. Sharp, you're not on the account here. I can't talk to you about this. Okay, well, I'll call the cable company. I'm sorry, Ms. Sharp, this account's only in your husband's name. We can't do anything about it for you. And so very quickly, she called some of the credit cards and said, I need to stop payments. I'm sorry, Ms. Sharp, we can't talk to you. Your name's not on any of these accounts. Okay. So what do we do in that situation? We're stuck with going through guardianship. And in this situation, we went through what's called a temporary guardianship. I think it's temporary somewhat appropriate because it only lasts for 60 days. The better term is emergency guardianship because this is something you get in place within, you can get to a hearing within about 10 days on this. But so what happens here, this situation, remember this, my brother and his wife are married, that she has to prove that she can be guardian. So we go to court, we file an application. Okay? We have to immediately serve him with notice. So we get a process server to go out and visit the hospital and serve my brother with notice. So what does that look like when somebody's in a comatose state?
Yeah.
It means the process server shows up at the hospital and leaves a packet of papers saying you've been sued by, your spouse is suing you to take guardianship over you. Leaves it on his hospital bed. 5 minutes later, the nurses come in and move it over. So he has no idea. The next thing they do is the court appoints an attorney ad litem. So an attorney ad litem means just a court-appointed attorney to represent him. To make sure that we're not making this story up, that he really is still alive, he really is in the hospital, we really do need to take care of him. And so attorney friend of mine, the court appointed an attorney who was a friend of mine named Brian Maverick to go down there and represent my brother. And so Brian walks into the hospital room and says, hello, Mr. Sharp, I'm your court appointed attorney and have been appointed to represent you. Are you okay with your wife serving as your guardian? Do you have any problems with that? And of course, he didn't respond to anything there. And so guardianship, so he does his thing. The court investigator, in most situations, will also go out. The court, depending on what county you're in Bexar County, both courts have a court investigator. The smaller counties do not, but the court investigator would also go out and meet. And then after all of that happens, we can come back to a hearing. Okay. I forgot to mention up here, in most guardianship situations, in temporary, you can get away with not doing it right away, but you've got to have a certificate of medical examination. So you have to have a doctor that will certify that the person is incapacitated. So we get the medical examination, then we can go to a hearing, at which time we can get this person appointed as the guardian. So we get down here, we finally have the ability to get this person appointed as guardian. And now they can make some decisions and can handle things. So this process is the same whether it's temporary or whether it's a permanent guardianship. The only difference is timeline. So I mentioned in the temporary guardianship, we got to this hearing within 10 days. Right? If it's a permanent guardianship, we're seeing these things take about 9 months, or I think they're averaging about 9 months now. It used to be 60 to 90 days. But now that guardians have to have, potential guardians have to be background checked. They've created government has created a new system, and believe it or not, it doesn't work efficiently. So it's taking a surprise, yes, it's taking a long time. So that's slowed down, and so now we're sometimes seeing 9 months before we get to a guardianship hearing. That can be a big struggle in some situations. So. And then the cost of this, for my sister-in-law, it was not too expensive. She only had to come up with about $400 to pay court costs and filing fees and that sort of thing. And this guy ended up not charging us anything because he was a friend. But if there hadn't been that scenario, if any of you were in this situation, this process is probably going to cost about $5,000. just to get to the guardian. Okay?
But we're friends now, though, so.
You'll have all of our cards.
I typically only charge double for close friends. So,
And your brother.
so in that, but so you can see real quick, this can get really tricky. We could have avoided this with two simple documents, a durable power of attorney and a medical power of attorney. And we had those two documents, we never would have gone through any of this guardianship mess here. So now we're down here, we have her appointed as guardian. That means we're done, right? We don't ever have to go back to court, we don't have to do anything.
No, it's temporary.
Well, okay, so you're right, I said it was temporary. Let's say this is permanent. It's permanent guardianship. We still don't have, so now we're done, right? She can handle everything, she can sell property, she can do all of those things.
No.
No,
That's
okay.
right.
If you're a minute ago, we've got somebody in here who has,
Oh, heck no, I
Guardianship.
every year.
yeah, so she now, so if guardianship becomes permanent, then yes, we're going to have to file an annual report on the well-being of the ward every year to say, these are the number of doctor's visits we went to, these are all the current physicians, current dentists, this is the recreational activities we've involved this person in, these are all the different things that we've done. Sure, you may get a visit from a court investigator once a year. That's just for guardianship of the person. We're not even talking about property yet, so that can be, so now we've got a file an annual report. Typically, you can do that annual report on your own. You typically don't have to. If it's just guardianship of the person, you may not have to have an attorney file that report for you every year. But you can, so you spend $20 a year, I think, with the clerk to get your updated guardianship letters. If it's guardian of the estate, it can be, now you have to also do an annual accounting every year to show every dollar that was spent of this person's money, how it was spent, and what went on there. This means.
So you had mentioned the medical power of attorney and the durable power of attorney would have been offset this. Do you also have to get this HIPAA release done when you do a medical? Is that something that's commonly done together?
So most of the time, at least anybody that's doing medical powers of attorney now, there will be HIPAA language within the medical power of attorney.
Okay.
That's pretty standard. The reason that we would do a separate HIPAA release is because the separate HIPAA release can survive even beyond your death. So up to 2 years after you pass away, which can be really helpful for the family if they're trying to figure out what happened or if there's a medical malpractice suit or anything like that. So that walk into the reason we do something. Okay. All right, so we've got this down here. Let's say in this scenario, they figured out they can't live in the home anymore. They need to sell their home. Wife is now appointed guardian. Can she just move forward and enter into a sales contract and sell the property?
Guess not.
I probably wouldn't ask the question if it was yes, correct? Okay.
Well, you mentioned the durable power of attorney before, so.
So in this situation, so let me move this back out of the way. We have, she is guardian, but guardianship, being the guardian doesn't mean you have full authority to do everything. It kind of means you're the representative for the person when things need to happen. And so let's deal with a real estate transaction. You cannot just go sell the property. You have to get the court's approval to sell the property. So if she decided we need to sell this house, we'd have to go to court and ask the court to approve selling the house. And so the first thing we do is apply to sell. Then we wait and hopefully the judge looks at the document very quickly and says, yes, you can sell this property. Once you have the court's approval to sell, now is when you can enter into a listing agreement and get the house, put it on the market to sell. Then you get a contract. And so you think, great, contract, let's do our 21-day close and get it done, right? We love those 21-day closes these days, or 30-day close. The reality is no, that's not gonna happen, because once the contract is signed, then it has to be filed with the court. It has to sit there a minimum of 10 days. After 10 days, the judge can look at it and approve it or deny it one way or the other. And so So now we're about 2 weeks in, we're hoping the judge is going to, after you've done all the work to get the buyer approved. Now we're hoping that the judge signs off and approves it. The judge may ask for revisions. The judge may ask for, most of the time, their judges are going to be okay with it. Sometimes where things get tripped up is when there's it's a really expensive property, or you're trying to sell, or you've got a situation where you're trying to sell it below market. We've actually had to take real estate agents into court with us to testify. We're selling this at this rate below market because for these specific reasons. And so there can be some issues there. Then once the judge has signed approval for the contract, then you can go to close and then would file a decree confirming the sale afterwards. So after we've waited 9 months to get the guardian appointed, now we're gonna have to file an application with the court and wait another 2 to 3 weeks, hopefully, to get the approval done, or we'll have to wait hopefully 2 or 3 weeks to get the approval to sell it. Then you put it on the market, and then you wait again for the judge to look at it again. These things should happen quickly. Guardian, we're finding in our courts that unfortunately right now, nothing is happening really quickly. We've had, Jeff and I personally have got a case where we've been waiting about 9 months for the judge to sign off on an accounting. And they just came back and asked for more receipts after they'd asked for something else 5 months ago. And so it's been it's just been a real struggle to get things moving through the system quickly.
Who's accountable for filing that last decree?
The guardian.
The guardian? With the courthouse?
Yeah, they file it with the court. So typically you would go through an attorney to do this. And so we've spent about $5,000 to go through to get a guardian appointed. And then you're going to spend depending on how complex the finances are, you're going to spend some attorney's fees every year to file annual accountings. And anytime you need to sell property like this, there's a document, several documents for an attorney to prepare and all those things. And so for every piece of property that needs to be sold, you're probably looking at $1,000 to $1,500 in attorney's fees just to get something sold or get through the system, especially when you've got. And you need to make sure your client's working with a lawyer who is familiar with probate court judges, and the judges are familiar with them, because some of these things you're not setting hearings to go down through. You're just walking into court, hoping the judge is around that day and asking them to sign it for you on the spot. That's how you get these things through quicker. If you're somebody who has never practiced in that area of the law and the judge doesn't know you, then they're not likely to make any extra time for you. Okay, and so they'll say, "Oh, leave it with the staff," and then you come back, several days later. Has it been signed yet? Has it been signed yet?
Would the title company on the sale ever file the decree for you?
I don't know the answer. I have not had that happen. Because it's not, probably not, because it's not being filed where they normally file. It's not going on the deed records, which is where they typically file with their documents. So they're probably going to put that on. Any questions on guardianship before we move on? Okay. Well, then let's talk about wills. That's the next document on the list. A will is just simply a document that says, this is who gets my stuff when I pass away, and this is who's in charge of getting it or taking care of it, of distributing it. Remember, the executor has no authority until the will has been admitted to probate. And we'll cover exactly what the probate process looks like in a little while. But you will have people that call up and say, my mom passed away, I want to sell her house. Okay, well, have you probated the will? I don't need to do that, I'm the executor. Well, the executor doesn't have any authority until the will has been probated. And so if they continue to say, no, I'm in charge, I'm the executor, say, well, then do you have letters testamentary, or do you have an order admitting the will to probate? If they don't have those two documents, they're going to need to get them for you before you can close that transaction. And so now if the person died without a will, then we're stuck with what we consider a dirty word in our office, intestacy. It's a very, very bad word, because that means they died without a will, there's not a plan in place. What now? And the reason that we think this word is so bad is often the person who thinks they're going to inherit doesn't actually inherit the property. This has happened multiple times. Most people assume that the property goes to the spouse when they pass away. Unfortunately, in blended family situations, that doesn't always happen. So if you remember, when you took your licensing exams to become realtors, you had to have some understanding of community property, right? Okay, does anybody remember what the definition of community property is?
We're the new people. One to buy, two to sell, that's what I know.
One to buy, two to sell, I like that one.
Yeah.
Some of us learned it, well, what's hers is hers and what's mine is hers.
Yeah.
But, so the definition of community property is all property that is gained after marriage except by gift or inheritance. So if you inherit something, it can remain your separate property. If you are gifted something, it can remain your separate property. Otherwise, with a few exceptions, their property that you gain while you're married is community property. That means you each own an undivided 50% of that property, right? Or you each own 50% of that property. So let's use a scenario here. I'm going to use myself as an example. So we've got husband and wife, and I mentioned earlier we have 4 children, right? And so we own a home together as community property. And so we're only going to talk about community property here for this example. Now, I pass away. What happens to that house? Where does it go?
Half of it belongs to your wife. Probate.
And half belongs to your heirs.
And that goes half to the wife,
Or
half
four.
to the kids.
Unless
Have
there's
to
a
watch, have to
Okay, so let's split it up from the beginning.
Yeah, but
Is
you're an
remember-
attorney, so you made sure that didn't happen.
So, remember, we split it up, we'll assume I don't have a trust or a will or anything like that, but, so, we know that she owned 50% already, right? She keeps, so she's gonna, no matter what happens to this half, she's gonna keep her half here. So I heard several answers from you. I heard from this part, half of it goes to her, half of it goes to my children. I heard this all goes to the children. I don't think anybody said that it all goes to her.
No.
No, nobody said that. You should have, because you would have been right.
Ah.
So in this situation, if I pass away,
Not so complicated.
everything, if I pass away, everything goes to her.
Does it matter whether the children are minors or not?
Does not matter whether or not the children are minors. But for that purpose. Right? So the reason that it all goes to her has nothing to do with their age. It has to do with these 4 children both have the same parents.
Yeah.
Okay.
Gonna
So
say
I was
blended
just gonna
would be different.
ask, what if, I mean, maybe you've declared that those are your kids, that yours and your wife's, but what if 2 of them were yours from a previous
Okay.
marriage?
Well, let's leave this. So we've got these 4 kids together. But before we were married, I had a child over here. Now I pass away. Where's my half of the estate go? Who's going to own this house? Let's just say it's a house. Who's going to own this house?
Well, if you're still married to her, doesn't it go to her?
Depends on how you guys acquired the house. Was it your house first and then?
So I mentioned earlier, it's community property. So there's,
So half
Is
is
it
to
a
her,
half,
half goes to.
a half of his to the child and the other half to
So
her?
you think of my half here, half goes to this child and the other half goes here to her.
Still goes to the wife.
Okay,
Still goes to
Several people are saying it still goes all over here. Anybody want to give me the right answer? Jeff?
The kids.
So it goes to the kids. My half goes to the kids. Which kids?
All 5.
All 5 kids, right? So now, so this, saying this is a half, so this child now owns 10% of the house. This child owns 10%. this child owns 10%, this child owns 10%, and that leaves 10% for this child.
Is that another one of those hard cases making bad law?
Okay, and you
So-
said that was
so-
community property.
So this is our community property. So why does the court do this?
To not,
So
to not exclude your biological children with your wife, because if we're giving half to your child that you had before you married your wife, then you have to include the other 4 biological children. So it's an even
right,
split.
because the court believes that if this child didn't exist, the court presumes that my wife is going to care just as much about our children together as I do, and so they expect that she'll take care of them. Right? The likelihood in most cases that she's going to care as much about this child that was around before she was is a lot lower. And so the court wants to protect this child's interest, but they don't want to protect it to the detriment of these 4. And so it just makes it clear my path to go to all of my children.
So what if she adopted the child?
If she had adopted the child, then
Would be considered.
It's theirs.
then it would be treated as the same as this.
Okay.
So that's 50%.
It's
Now let's say
50%.
none of those were your biological children, and you only had your one child, then it's a 50-50 split.
Yeah, so if these 4 were hers and these 4 didn't
Let's
exist,
say those 4 didn't exist and you only had one from your previous
then
marriage.
he would get the whole, he would get my entire 50%.
Right.
That's the other 50%.
And then she retains.
It's so complicated
I know
these
that
days.
makes a difference.
Scenario.
I just get
No,
it.
So my entire half goes to my children.
So it's 50-50. She
Well, it
gets
only
50, but then the
Well,
10.
50 plus
50
50.
is 100.
She had, because she retained her 50% interest.
Yeah.
So 100% of my 50% goes to my children.
So what does that do
That would be like Greenland.
With title of the property, that means, so her question is, what does that do for title to the property?
Good question.
So, well, what the title does is it's now in these percentages. She owns 50% and each of these kids owns 10%. Now, she decides that, or we figure out that we live in a house that's bigger than she can afford on her own, and I wasn't smart enough to get good life insurance out there. So she doesn't have enough money to stay in this home. She wants to sell this house. Now, these kids, I mentioned, are 5, 3, 2, and 2. And this child, we'll say he's 15. Okay. Who does she have to talk to in order to sell this house? So for this 10%, this 15-year-old's 10%, he's 15, he's a minor, he can't make the
So
decision.
it'd have to be a
on his own.
guardian.
So he's gonna have to be a guardian. Who's likely to be his guardian?
Biological parent.
His mom, his mother. Are they like, is she likely to get along well with my wife? You know, no, they're probably not. Right, there's probably- So in order for my wife to sell the home so she doesn't go bankrupt and get foreclosed upon and that sort of thing, she has to go to my ex-wife and say, would you mind getting guardianship over your son so that I can sell my house? And so it's a huge mess.
That's gonna cost.
It doesn't stop there though.
Yeah.
Remember, these children are minors too.
This is all you're talking still laws of
Intestate
intent, bad stuff, but you could
Yes.
avoid all of this with.
Yes. So.
The will.
So again, these children are minors too. Can she just sell their interest?
I don't know. I mean, is she automatically their guardian or does that have to be appointed?
So the question is she automatically the guardian? The answer is no. You're automatically the guardian person. So you automatically get to make medical decisions, placement decisions, living decisions for your children. But if your child inherits a bucket of money, you're not automatically the guardian there. You have to go to court to be appointed as that
That's what I was
guardian.
afraid of.
So she would have a couple of choices. One is if the equity in these, for these children was substantial enough, she would go through the process of guardianship. Guardianship in this type of scenario, probably not $3,500 per child, $500 to $4,000 roughly. Okay? Because each one of these children is going to have their own attorney appointed. Well, we're going to go through that process over and over again. If the money was not substantial enough to make that make sense, we could go to court and ask the court to pay their portion of the equity into the court registry. And then when they turn 18, they can go get it. And so in scenarios like this, we often do that. But that leaves her without, remember, she's only getting maybe 50% of the equity now in that property. And so it can get a big deal. So two things we should have learned from this scenario here. One is
Don't
Yeah,
know,
well,
yes,
it
they-
will.
get a will, and two is have good life insurance, have enough there to cover, so your child doesn't have to leave the house.
Are there situations, and I assume it would be with adult children, where they want their money out of that house and the mother is forced to sell it to give them their part? Is that correct?
Okay, so good question there. So we're talking about homestead real estate here. Okay? Let's say all the children were over age 18 now. So this child here is 18 years old. He says, I want my 10% value of this house. So I want you to either buy me out or I'm gonna force a sale of this house. Can he do that?
I would
It's her
think
homestead,
so.
right?
Right, homestead.
Oh,
Going back to your exams again, she would have a homestead right there, so he cannot force her to sell. He cannot kick her out. She has the right to remain in the home for her lifetime. That's one thing. If it's not homestead real estate, then there can be disputes with her or forced to do that, but they cannot force her out of her home.
But she can't sell it either without his permission.
But she can't sell it either, because he has that 10% interest.
So you just have to outlive all your children.
Get a will.
Yeah, or have a will in place.
Don't include the kids.
Yeah, this happens, this can be this happens unfortunately to be a big struggle a lot of times because it's young couples a lot of times that don't have a will in place and they have minor children. And so we see this way too often where we're trying to figure out what to do with the situation. And this, go ahead.
Well, this is a little bit offside, but where does the affidavit of heirship come in?
We'll cover that.
Okay, you'll do that later. Okay, thank you.
Yes, ma'am.
But even if you have a will, they can still fight it in probate, can't they? Even if you name that the house is to go to your wife or.
Yeah, I mentioned those guys we call litigators earlier. Yeah, if you can write a check, they can figure out a way to contest it sometime. But the likelihood of it being contested if your will is done well is a lot lower. So having a will in place can avoid a whole lot of litigation.
what does it cost, average cost for a will for some?
We'll get it. We'll
Okay,
cover it.
okay.
We can talk about
So
costs.
for some people that,
Just for my
The young
understanding,
couple
so
that I know.
in this scenario, the firstborn, he might not get his 10% of the share until A, she passes away, or they sell the house.
Correct. Yeah, same for all of them.
Pay for all.
Okay, unless if she's ready to sell the house, then she's gonna have to negotiate with them to get there.
I had a friend in a situation. She and her brother their dad died. Their stepmother was named executor of his will with nothing divided up. She had 5 other children and she divided it up for herself and those children, and the biological children got nothing.
So you're talking about my dad?
Is
That's what happened.
This happened years ago. I'm just
Yeah,
wondering how
it's
is that
possible, but I'd have to look at the will to know what it said.
That's exactly what happened.
Give you advice on that, but it happens, it does happen a lot. Okay. So intestate administration, I'll move this back. So intestate administration is the process of clearing title to assets when there's no will in place. This never is going to happen in less than 60 days. It can happen in that 60-day period if everybody agrees, if everybody kind of gets along and we know who the heirs are. We can a lot of times get it through pretty fast. But if there's not agreement, or if there's this, especially if there's issues with minors, we have one case, the same case I mentioned earlier, we're waiting on final accounting and it's been sitting there on the judge's desk for over 9 months. Is this almost exact scenario. Husband passed away. He had a child from a previous relationship. That child was over 18, gets along well with wife, and she's got minor children. But we have to go through dependent administration. We've been working on this case for about 2 years now, hoping just to get it closed up, even when there's nobody fighting. You have to have the attorney ad litem was appointed in this case to check on unknown heirs to make sure there aren't anybody else that we're somebody's lying about. I don't know if your clients ever lie to you, but I've had a few of mine lie to me. I have one story I'll tell you quickly where we have kind of an intestate administration. I had a client coming to me, talk to me about his father passed away, and he mentioned his 3 siblings. And I said, okay, you've got 3 siblings, and we filed paperwork with the court, and we got everything down. His sister was feeling kind of uneasy about it, so she went and talked to an attorney on her own, and that attorney called me up and said, hey, I just read through all the pleadings. I've seen the 4 that you've mentioned here, but can you ask your client about somebody named Frank? And I said, okay. And so I've talked to my client a lot. I've never heard mention of a Frank. He says, well, call your client and then call me back. So I hung up the phone, feeling kind of stupid. I call my client, I'm like, hey, I just talked to your sister's attorney. He wants me to ask you who Frank is. And he says, oh, Frank. Well, Frank used to be our brother. Coming in? Yeah, he used to be our brother, but we haven't seen him in about 20 years. So, well, he didn't stop being your, why do you say used to be? Was he adopted? Was he, whatever? No, we haven't heard from him in a long time. Well, he's still your brother. We need to amend our pleadings here, and because the other side is now threatening to say that you've committed perjury in court by filing documents that you knew were false. And that sort of thing. So we're going to go ahead and make this. Okay, and so we had to include Frank in that situation.
Did you find him?
Frank was found, and so Frank got his instead of getting 25% each, now everybody gets 20%. Minus a few attorney's fees that our client agreed to cover to keep everybody from suing. So it's important. So that's why the court appoints this attorney ad litem to come out. And I've been appointed in scenarios where son is trying to push the probate through, and then we find out. And so they appointed me as the attorney ad litem, and I find out, well, he's been living, the dad before he died had been living with the same woman for the last 20 years, and she happened to wear a wedding ring. And, and everybody I talked to said, oh, no, they were married. And I said, oh, okay. And so it was an informal marriage, but that counts the same as a formal marriage if you meet the test. And so.
What do you mean by informal? Meaning they just went down to the courthouse,
Common law?
or they did it
So
at a big church?
informal is the new word for common law.
Mm.
So common law.
10 days or something?
Anybody-
Introduce yourselves as husband and wife.
She got it right up here. The test now is that you hold yourself out to be married to at least one other person.
At least one.
At least one other person, yeah. So if
Wow.
you, so let's say my wife and I were not formally married, and I went out and I said, hey, Jeff, this is my wife, Olivia. And we walked away, and 10 minutes later, Olivia is yelling and screaming at me, why did you introduce me as your wife? We're not married. And well, she didn't correct it with him.
Mm.
And so we've held ourselves out to be married. And so there could be an argument there. So if anybody introduces you as their spouse and they're really not, you need to immediately say, no.
In the presence of witnesses.
If
That is
anybody updates their Facebook status to say they're married to you, you need to immediately
Right on
get
their
on
wall.
Facebook and say, no, we're not.
Wow.
Because you could, and especially if you're living together, or if you're doing, because that holding out can be very.
Not every state has common law.
Not every state has common law, or what we now call informal marriage.
Do you have to be a witness to somebody saying they're married to you, or is it just somebody down that you've never met can say they're married to you?
Well,
To somebody else, I mean, that's pretty close.
It needs to be both of you holding out to somebody else.
So it's not, okay.
So in that
Like
scenario
a
there.
stalker can't be like,
Yeah,
I'm married.
in that scenario, it works that we were both holding out because she was involved in that conversation. She didn't correct. She had the ability to correct it.
Does living together constitute holding out?
No. No, you can cohabitate and not be married. But if you are, so, but,
So it's a declaration.
yeah, but if you plan, if you call each other husband and wife, even just playfully, and you do it in public, then you are married. Eventually.
So what's the Texas?
I'm putting that on
law,
Facebook, so
um,
people
about
know.
common law marriage? Is that not
I've done that
Texas?
since I was
So
a kid.
we call it informal marriage now. That's the holding out.
But you have to actually say it out in public. It's not just living with somebody for 7 years.
Correct. There is no time limit.
That doesn't apply in Texas.
That is not. That does not.
So you should have informal divorce as well.
Yeah, I mean, so we've had that had to go through divorce
Yeah.
proceedings that didn't realize, one of the parties didn't realize they were really married, because but they've been living together a long time. They thought they were just boyfriend, girlfriend living together, and then they get served with the divorce papers one day because, well, the spouse that's leaving would like half of the retirement account and those sorts of things. So be careful if you're cohabitating. Be careful if you like to call other people your spouses that you're not sure really are, or that you don't want them to be. So, intestate administration, you're also going to, the other problem, getting back on this, the other problem with intestate administration is you gotta have two disinterested witnesses come to court to testify that they knew this person. And so, let's say Mr. Smith is 85 years old, moved to Texas when he was 75 because he wanted to be closer to his children and take care of them. And now he passed away with no will. Finding those witnesses that knew him around the time that he was having children, is going to be very difficult. And so because disinterested means that they can't, there's different definitions of disinterested. One legal definition that I used to really like is when they just said somebody who's not inheriting. And so they were happy to have cousins and nieces and nephews. Judges really like now to have people that are not related in any way. And so finding friends of somebody who's 85 years old when he passes away can be really, really difficult sometimes. And especially long-term friends that would have had conversations about children or would have known that when he was in his 20s, he wasn't going around having lots and lots of children. It's a little bit easier when women pass away because they're pretty clear when they have children. There's either something biological that happens to them, or there's court papers that say there's an adoption that took place. But for men, it's still not quite as easy to figure. Yes, ma'am.
The informal marriage,
Mhm.
calling someone a significant other, is that not the same?
No, it would not be the same. But simple things like, we'll go back a little bit. Most of you remember Blockbuster Video. But used to, you could have a Blockbuster Video membership for spouses. And so we've used in court, not me personally, but we've used in court evidence of Blockbuster membership card where they listed each other as spouses. And maybe they were just doing that to be on the same account, but that is good enough evidence. Yeah, maybe. Thankfully, I mean, most of those things you can have a person, but if you identify that person as your spouse, you have now held out to them. The law has been a little bit different. Now, there are some people who have, the court, I'm not sure how the court came to this ruling, but the court determined there's one case out there where they filed joint tax returns. So they told the government they were married, or I'm sorry, it went the other way. They filed separate tax returns for the lot. They lived together for 20 years. They said they were married, but they told the IRS they were not married. And so the court still was able to find evidence of informal marriage, even though they've been telling the IRS. And we argued, well, isn't that tax fraud? But so, well, what you tell the IRS is different from what you tell your friends. So I'm not sure on that one, but
Didn't
But
it
it
start
can
to
be.
protect women? That they'd have a right?
yes, I think informal marriage. I mean, I'm not really up on the history of it, but I think it did have to start so that women, if they were thrown out, they could of the home, they could claim, hey, I've been here, you owe me half the, I don't know. All right, so probate in general is the, now we're talking about probating a will. That's the process of looking at the will, having the court look at it and say, yes, this will is valid. The things that they're going to look at to determine if it's valid is how was it executed? So was it signed with a normal signature? Was it witnessed? So did we have two disinterested witnesses witness this signature? Was it self-proved? That means, was it notarized was everybody's signature notarized? Signing a will as a witness can be a big deal because you may have to go into court to testify that you were there. And in fact, just this week, my wife, about maybe 6 or 7 years ago now, we had a client who was bedridden, and we went out to his home to sign, to meet with him and his wife, and he signed wills. He ended up living another 6 or 7 years, but at that time he was so weak. While he was mentally sharp, and we were able to talk through a lot of things, I had no question that he had full capacity and he knew what was going on. However, physically, he didn't have much strength in his arms and his hands, and so we helped him sign by making an X on the form. That was the only signature he had. I was there, I notarized the signature because we went to the home and it was 6 or 7 years ago. I only had one other staff member, so I took my paralegal at the time and called my wife and said, can you come with us? And so that was she was the other witness. And so we got over there, signed the documents. Well, fast forward 7 years, he's passed away. We filed the will with the probate court. Even though it had me as the notary on it as the self-proving affidavit, the judge wanted a little bit more. They wanted to bring in the witness, one of the witnesses, to say, yes, I was there and I saw him sign this. And so we had her come in and point to the signature and testify that, that she was there, that she did remember the day. My wife doesn't go to a lot of those things, so it was very easy for her to remember specifically, yes, I was there, I typically remember very well when I go into somebody's home or hospital situation. So witnessing is a big deal. When you ask to sign a witness, you may come to court 7 years later. Okay. So we have to determine, part of probate then, after the will is admitted to probate, is determining which assets are probate assets and which assets are not probate assets. So think of things, when we say probate, think of things that are controlled by your will if you have one, or controlled by the laws of intestacy if you don't. So things like your house or other real estate, your personal property, the things that are in your house, your things you can touch and feel, your cars, the cash you have buried in the mattress or buried in the backyard or stuffed in the mattress, and your business interests, so ownership in a business. These are all probate assets. On the non-probate side, we have things like bank accounts, life insurance, 401ks, IRAs, brokerage accounts. If something is left blank, then it comes back over here and become a probate asset. So if you have something over here with no beneficiary, then it becomes a probate asset. So let's do an example here. So life insurance. I opened a life insurance policy in the year 2000. Okay? And on that, there's a $100,000 policy. On that beneficiary form, I put my dad down as a beneficiary. Okay? And so now in the year 2010, I decided that to go ahead and do a will. And in that will, I wrote my life insurance policy with American General Life Insurance Company, number 35, policy number 35, I wish to go to my spouse, period. Then I die. where does that life insurance policy go?
Your dad.
Your spouse.
Okay, dad, spouse, spouse.
To an attorney.
You're right.
Your first child.
First child. Let's throw somebody else in there.
But were you married in 2010? You just put down.
So I was married in 2010.
You were, okay.
But 2000, when you took out the policy, were you married? And again, you don't have to be, if that's the beneficiary that you put out there, right?
Yes, ma'am.
I was gonna say, the life insurance company is the one that has the paperwork, and that's who they're gonna make the check out to. It doesn't matter what the will says, because that's where it's over here.
Correct, yeah, so it doesn't matter, whatever my
Yeah, I say
beneficiary,
that, and I have
whatever the
to-
beneficiary designation says, that's who gets it. So dad wins, wife loses in that
Yep.
situation. And a lot of people say, well, shouldn't it be the last document that was signed? You know,
But that's,
you know,
it's a
because I
contract.
mean, it's clear, but it's clear that my intent, I mean, I signed this other document 10 years later. It's clear that my last intent was for it to go to my wife. But it doesn't matter because that we have a contract with the life insurance company. They have a contractual obligation to pay it to the beneficiary that I chose.
So if you change your beneficiary with the life insurance policy.
And it's easy.
So yes, I have to go change it with the life insurance
And
company.
if the person that you have on your beneficiary dies before the person who has the life insurance, then it's a whole other process.
Yeah, so if
There's usually
my
a
dad had
contingent
passed away,
beneficiary.
then it would, if I didn't have a contingent beneficiary, then it would come back to my estate. And so then it would become a probate asset and the will would control it. Or if I had put, which I don't recommend this, but if I had put the beneficiary on the life insurance policy, if I just wrote my estate, then the will would control it. But,
Well, and then there's tax
reason-
implications
another-
too when you do it that way.
Yes, there can be.
Because life insurance isn't taxed if it goes to the beneficiary.
Correct, for income tax purposes. It does count towards estate tax
Right.
purposes. Estate tax, we're not too worried about for most clients, because the estate tax exemption is 11.4 million this year. Yeah. So, I mean, Jeff's my tax guy. in the office, but so if your estate is under $11.4 million, we don't have to worry about estate taxes. If you're married, we can double that to 22.8 before we really.
So you've got under the bank accounts, that's joint tenancy, I think is what you're probably referring there to,
Yes.
A and B, so that if you've got, if the deceased is on the bank account with somebody, then is that affected?
Yeah, so if my wife and I pass away, she's a joint on the account, she immediately gets everything in that account.
Okay.
Same
Oh, with
if I-
survivorship, is that what that's
With
talking about?
survivorship, joint tenant right survivorship. Or if she's a pay on death beneficiary, she gets those accounts, those pass outside of probate. So there's no worries about how to deal with those things there. But another reason that it's good that the law is set up this way is, what if it's this scenario over here, and I do a will, and in my will, I say I leave everything to my spouse. But I want something to go to my child from a previous marriage. So what I do in that scenario is I go get a life insurance policy, and I name that child as the beneficiary of that policy. So even though my will says everything goes to my wife, I have a policy outside that passes outside that. Take it, and that's a really good idea with blended families, because then you keep the peace with your spouse. They don't have to deal with the ex-wife, the children from previous marriage, but those children don't feel like they've been cut out.
And the thing is, you can do single premium life insurance policies too.
Okay. So probating a will, we mentioned earlier, the executor can typically be appointed in a couple of weeks. You've got, the process looks like this. We hire an attorney, we file that application. We go to a probate court hearing, usually about 10 days later. We have to file, notice to creditors should be ahead. Notice to creditors is due within 60 days. Inventory is due within 90 days. And if everything is smooth and you feel like you've paid off the debts, then we can get the distribution. It can happen pretty quickly. So we have had scenarios where I mentioned earlier, what happens if you're in the middle of a real estate transaction and dad passes away or your client passes away, what can we do? So we had this scenario or last year, daughter was using power of attorney to sell dad's house, got a contract on it. Dad was not doing well, but he was still around well. She signed the contract as power of attorney. or closing was supposed to happen on Wednesday. He died on Tuesday afternoon. And so put the brakes on. It means on Wednesday, we can't close that deal with the power of attorney anymore because he's now passed away. The power of attorney expired the moment he died. Luckily, he had a will in place. And so we got on the phone with the real estate agent, said, hey, can you extend, both agents said, can you extend this deal for 21 days? Because we think we know that we've looked at this will already. We're going to file the will for probate. We're going to get to a hearing in about 2 weeks. And at that hearing, we're going to get letters testamentary immediately. The moment you have letters testamentary, you can go down and close the transaction. I've had some, where we've closed gone to the probate hearing on Monday and closed the transaction on Tuesday. There may be some additional things that the executor has to sign off on. The title companies would like for this inventory to be done and approved by the court before closing happens. They will accept, and correct me if I'm wrong, but they will oftentimes accept an affidavit just stating that the estate is under the $11.2 million. There's not going to be an estate tax return necessary, that sort of thing. That's what they're waiting on. They want to make sure there's not big taxes that are going to be. This way.
Quick question. So this happened to me. We were under contract. We had power of attorney. Dad died. I remember the title company telling me there was something that we could have gotten that would have avoided that next process if we had known he was possibly about to pass away.
Was it quick claim deeding over to someone else?
Potentially, it depends on the scenario. There are what's called transfer on death deeds now that can change title to real estate. They work really well if you have a single beneficiary. So I have one son, I want that son to receive this property, or I have a spouse and you can do you can have it the moment of death. It treats it just like a pay on death bank account. And so the title transfers over. For spouses, you can do now community property survivorship agreements that treat the house like a joint bank account, basically, that allows that to happen, so you can get out of that. So there are a couple of things that can be done there, but in most scenarios, if we're talking about a will-based plan in place, then you're gonna have to go through probate.
Okay.
Yes, ma'am.
Is it very often required that there be any kind, assuming there's no sale in place, okay, because we moved on to that, but you're just going through a death and a probate process, is it common to require an appraisal to be done on the house in the probate process?
That, the question is an appraisal ever required on a probate? It depends on the number of beneficiaries and kind of.
Because I've seen it both ways, that's why I'm asking.
It really depends on the number of beneficiaries and how well they get along and what they're looking, the total value of the estate. If it's, again, if it's a single beneficiary situation, then there's not going to be an appraisal unless we're getting into taxable estate territory. If we're close to that $11.2 million, then we're going to get every appraisal we can. Hopefully, I'll come back low so that we can squeeze under that without owing any estate taxes. But
so it really is a case by case.
The majority of the estates we don't do appraisals on.
Okay.
Because if there's an independent executor, it's kind of up to that independent executor to decide when to distribute this, whatever. If the independent executor is afraid that the beneficiaries are going to challenge them or going to give them problems, then we would recommend to that executor, yeah, you should go ahead and get an appraisal to protect yourself from future liability. But a lot of times it can be way more expensive than it's worth to. When you're probating a will, it's important to find the original. We can probate a copy, but it's more difficult. We're going to have to give some extra proof to the judge because the presumption is if the original's gone, the presumption is you tore it up, didn't want it to be around anymore. And so having to kind of overcome that presumption and say, no, in my experience, most of the time, if a will is missing, if the original is missing, it's because the person who was cut out found it first. So, I don't get anything in this will. Let's get rid of this one and start from, because I get more if there is no will than I do if there is a will. So So while the presumption is that it's torn up, that's not been my experience in practice. Yes, ma'am.
So, when this happened to my husband, so when he was raised by his grandparents, and their will named him and their 2 sons
Okay.
as the executors. One of the sons had passed previously, before the parents did. Does it go to the deceased brother's children?
Depends on how the will is written. If there is a will in place, the will can choose to leave it per stirpes, where it basically goes to those children, and if one of the children is deceased, it goes down to their share, goes down to their children. It can be written, it goes in equal shares to just the survivors. And if there is not a will in place, then it would go that way where it goes to the children of the person who passed away.
My mother was heir from a 5th cousin, and it divided out to, I think it was 400 and something heirs. The attorney came to me because I kept family genealogy, and it was designated, I guess, in the will or somewhere, to only go down so many generations before the split was done. Now, generations below that could get the money if that person was deceased. That was years of work.
Yeah, it can be. Okay. Next, kind of talking about what is the job of an executor? Executor's job is to safeguard the assets. I've heard this more than once, probably more than 10 times in my office, where somebody has come in and said, well, I'm the executor, that means I get everything, right? No, that means you have all the work, all the responsibility, and you have the highest standard of making sure that everybody, all the beneficiaries get what they're supposed to get. So you may be an executor and also a beneficiary, but you have to treat all of the beneficiaries equally and have a fiduciary responsibility, which means you have to, you're held to a very high standard to make sure they're taken care of. Your job is safeguard the assets, present the will for probate, settle the estate as quickly as possible, and get the assets to the beneficiaries, file final tax returns if there are those things that need to be done. All right. Next, we're gonna start moving a little quicker to make sure we get everything, get through everything. So once you get your full value for the day. Muniment of title. This one is an alternative to probate. It looks a lot like the probate process, except that the hearing is the last thing we do. We don't have to file an inventory. We don't have to go through appointing an executor. So therefore, it only works with real estate, because what it does is we get the court to admit the will as a muniment of title, and then we file that order on the real property records, and we're done. So it's only good if it's only real estate. It's like, the reason we used to use muniment of title before is it was the only way to probate a will that was more than 4 years old, because there was a prohibition on probating any will over 4 years old. The prohibition it's no longer a prohibition, it's now up to judicial discretion, and so some judges will grant probate for good reasons after the 4 years, and others will not. So, but
You have to update your will every 4 years.
no, this is 4 years after death.
Oh.
So the person passed away and we didn't probate it for 4 years, that we just lived in the house. This happens a lot with married couples. And, husband passes away and they just don't go through, they had joint bank accounts. They didn't really think about it. The house was in both of their names, and they had that idea that, oh, I don't have to do anything because my name's on the house too. And so then 10 years go by and wife now decides she wants to sell the house and figures out that husband's name is still on the title, and they never probated his will. He's got a will sitting there. And so we're 10 years later, we're having to figure out how to clear title. And so maybe we use affidavits of heirship, maybe we use this muniment of title process. There are different things that happen there, but that's where we typically see wills not being probated within that 4 years. Okay. I told you we'd get back to affidavits of heirship. So this is in an intestate situation when somebody has passed away without a will. You can sometimes use an affidavit of heirship. Couple of caveats to the affidavit of heirship. And one of the things you have to swear on the document is that there's no debt. So if somebody passes away with a lot of debt, we can't really use the affidavit of heirship. Now, if we've waited more than 4 years before we dealt with this situation, we've passed the statute of limitations on debt, and so now we can say there are no debts that are, and we can do that. And so if you had somebody sitting there for a long time, then an affidavit of heirship is more likely to be useful. Again, you have to have the signature of 2 disinterested witnesses that knew the person. This document gets recorded with the county clerk. My experience with affidavits of heirship is if the person is trying to sell the house right now, then, or anytime within the next few years, then rather than having an attorney do it and just be done with it, you need to make sure that the attorney runs that by the title company that you're planning to use when you close the transaction. You need to make sure that they've blessed the document, because some of them, they want it in a certain format, or they want certain things in there that may not be required under statute. So, for example, nowhere in the statute is it required that an affidavit of heirship list the cause of death. It just has to say they passed away, and it follows from there. However, probably 8 years ago now, I had done an affidavit of heirship for a client, and they left. They got ready to sell a house the next year, and title company told them, we can't accept this affidavit of heirship because it doesn't list the cause of death in it. So the client called me very upset, saying, I thought we had taken care of everything a year ago. Why am I having this problem? I said, don't worry, I'll call the title company. So I'll talk to them. And so I talked to them and said, hey, they're saying they won't close this because you don't have cause of death on there. I said, yes, that's right. I said, well, that's not required under the statute. Well, we require it. So, but it's not required under the statute. How can we require it? Well, that's what we want. So I said, okay. And so I called the client back and said, can you have everybody come back in and we'll re-execute with the cause of death on it now? And we did it because it didn't matter. I could have, we could have gone back and asked to go to a different title company, but there's no guarantee that they would have had wouldn't have had the same issue there. We might have had to do that if we couldn't get those witnesses to come back in and re-execute the document. Thankfully, they did. But practically speaking, now, if we go through the title company ahead of time, we can make sure that they're comfortable with all of the language in there. And a lot of times the title company, when you send them in a contract, they'll say, hey, we've found, your first title report will have on there, we're going to need affidavits of heirship, and they will work with internal attorneys or external attorneys to get those prepared. And so you may not need to come to us outside, but if you've got somebody who's wanting to clean up issues, we're going to say, oh, are you trying to sell this quickly? Then what title company are you going to use? Because let's just get them to bless it so we don't have these issues.
Well, I was just gonna say, as it relates to real estate and what we can look for, that's where I came up with knowledge of affidavit of heirship, was that my friend, who I am selling her house, had her parents co-sign for her way back when she was in her 20s, and now she's in her 40s selling her house. And they had since adopted another child, and she had to get the child. Now, their relationship was great, and the child, who's now 20-something at that time, signed over that she had nothing to do with it at all. But that was a glitch in my own friend selling her own house that she paid every single payment on, but it was because she got a cosign. And I bet you there's millennials out there that are getting their parents to cosign.
We have a situation very similar to that where clients decided, or children decided to move parents down into the home with them, and they used money from parents to put down on the house. And so they put all 4 of them in title together. Well, 2 years later, dad needs to go into an assisted living facility. He's not going to be able to stay there, and they need money. And so we're trying to sell the house now, but dad has become totally incapacitated, does not have power of attorney. And so now we're trying to sell the house. We're having to go through guardianship over dad before we can sell the home. It's just a big mess there. Okay. We're going to move on quickly. Small estate affidavit is the next one. And this is a lot like the affidavit of heirship, except that it has to be approved by a judge. And so we use this one if there's real estate plus. So if there's real estate and a couple of cars, or real estate and a bank account that we need to get access to, as long as the property outside of the homestead, so there can only be one piece of real estate to use when you're using a small estate affidavit, and it has to be the homestead. It can be worth $1 million, it doesn't matter what it's worth, but the property outside of that homestead has to be less than $75,000 in value. So if there's, if there's a couple of vehicles that are, or that are under that, and a bank account with a few $1,000s in it that we need to get access to, and clear title to real estate, we can use small estate affidavit. We don't use them very often. It only works for spouses and dependents. Same kind of things, like you've got to have the disinterested witnesses come in. The biggest problem is you've got to get in front of the judge to get it signed. In Bexar County, you don't have to have a hearing. You just have to, you basically have to go down with the staff attorney to bless it, and then you put it on the judge's desk. If you're in Travis County, you actually have to go to a hearing on the small estate affidavit. So they can save some time in simple intestate administrations. All right, so our next, I want to make sure we cover this in the next 15 minutes. Trusts. Okay. You may come up with a client who's trying to sell property and they say, oh, it's in my trust. And that shouldn't be something that's scary to you. You need to understand that trusts are actually can be very simple. You go to the bank and deposit your commission check, you have entered into a trust relationship with that bank because they're serving as the manager of that money while it's there. You give it to them, they manage it, and you're the beneficiary. You expect when you show up to get it back. That is a very simple trust relationship. So think of a trust as we've got this bucket here, and the grantor puts stuff in the bucket with the trustee managing it for the person who benefits. So I can say, hey, I've got money here that I want to put this $100,000 in here. Jeff, I want you to manage this $100,000 for my wife and children. If I pass away, you're going to take care of that. Okay. That doesn't mean that Jeff, as the manager, that doesn't mean Jeff can go buy himself a new car with it. That's not his money. He has a fiduciary responsibility to manage it on behalf of the beneficiaries.
But he charges a fee for managing it.
He can charge a fee for managing it. So a lot of times, family members or friends may not charge a fee. The document can say they're not allowed to. We typically want them to be allowed to, because otherwise, why would they do it? And if you use a corporate trustee or something, they will charge a fee there. But it just says they're going to manage it for the benefit of somebody else. So that's simple. So but what you're going to see a lot of, and I say a lot of because more and more people are doing these every day. We used to, in our practice, it used to be about 70% of the time we were drafting wills for people and about 30% trusts. I would say, Jeff, would you agree? It's probably exact opposite now,
Yeah.
probably 70%
Or higher.
trust or maybe even higher. A lot of clients are doing these now. The living revocable trust is we call it living because you create it now while you're living. Revocable because you can revoke it at any time. We'll use the situation like mine again where we've got a husband and wife. So we are the grantors. We put our stuff in this trust. We are also trustees. We manage the stuff in the trust. And initially, while we're living, we are also the beneficiaries. We get the benefit from everything that goes in there. Right? So what that looks like is we take our house and we deed it inside of the trust. We take our business ownership interest, so the businesses that we own, we put it into the trust here. So that could be like an LLC or a corporation. Any real estate, so even rental properties and things like that, we can put inside the trust. We may put those rental properties inside an LLC if we want some protection, because the trust itself doesn't give any liability protection. I get that question a lot. But so having it inside the trust doesn't give us that liability protection, so we might put it in an LLC as well. But retirement accounts like IRAs and 401ks, we can make the beneficiary the trust. We'll typically make our spouse the primary beneficiary, and then the trust the contingent beneficiary if we have minor children. there. We take our bank accounts, so my bank account at Broadway and Frost is actually now in the name of the trust. So my checks still say Charles and Olivia Weisinger, but the statement I get from the bank every month says Charles and Olivia Weisinger Revocable Trust. Okay. Life insurance, we can make the trust the beneficiary. And then our will, we still do a will, and it's called a pour-over will. It says if I forgot to put anything in the trust before I died, when I die, we go through probate and it goes in here into the trust. So the reasons we do trusts, things like avoiding probate, that's the biggest reason that you would do a revocable trust here, is to stay out of probate court. You can use trusts of any kind to restrict inheritances. And so I've got children, I don't want when they turn 18 to just all of a sudden get all of my stuff. I want them to maybe at age 25 get a little bit, and age 30 get a little bit more. You can also use trusts for special needs beneficiaries and providing some tax benefits depending on the size of the estate.
But if you put your life insurance into that revocable trust, then you run into the tax implications
It is still not taxable as income tax.
in a revocable trust.
And a revocable trust. Okay. It still stays out of tax. Now, it will still be subject to estate tax. And then, so the role of a trustee is a lot like an executor. Follow the directions in the trust, protect the assets for the beneficiaries, and provide benefits to the beneficiary. Gotta keep trust records, gotta be accountable. I had a client who came to me, he had been trustee for about 20 years over his niece. The trust document said explicitly he is not required to do accounting. So the person who was passing away said, I want my brother to be trustee for my daughter, but I don't want him to be burdened with filling and filing, accounting, and all of those things. The courts said you can't give away the duty to account because the beneficiaries have to do that way. So 15, 20 years later, he had never done accounting. And unfortunately, he was a bad money manager as well, bad trustee, and he had lost most of the money in the trust. And now the beneficiary wanted an accounting, and so of course the courts required him to do an accounting. And so we spent the better part of a year coming up with contacting old banks and trying to recreate accounting records for 20 years of his service as the trustee. We had been through, he had lived in Hawaii for a time, and the bank there had been destroyed by a hurricane. So we had a hole in that. So if you're ever trustee, you just know, no matter what the document says, you have to keep it. Okay. Questions on trusts?
Can you give a brief description of the difference between a revocable and an irrevocable?
So the difference between a revocable and an irrevocable trust. The easiest definition is one is revocable, means you can change it. The other one is irrevocable, it means you cannot change it.
So once the stuff goes into
Once
the
the
trust,
stuff goes in, it has to be used for the purposes of the trust. And
Why
so-
would someone not do a revocable versus?
Like some examples.
I have an example.
I have one.
If you're going into Medicaid and you have to spend down some money,
Yes.
you have to put some money into an irrevocable area for a funeral. And that can be changed.
So it's some good reasons for doing irrevocable trust. Most of the time, we're looking at tax reasons. So it's either the very, very wealthy, and we're trying to get things out of the estate early so that we can you put items that are low value that we think are going to go up in value, so that we can stay below that $11.4 million in tax rules. Or we do it on the other side when we've got some assets and we're trying to get things out of the estate, so that family land, get it out of the estate so that it doesn't become subject to the Medicaid estate recovery program, and so we get it out of there. Understanding with Medicaid, now you have that 5-year look back period, so we can't qualify for Medicaid within 5 years of making that transfer. Other reasons, protecting special needs beneficiaries. If you're going to put money into a special needs trust, those need to be irrevocable because they're in order to qualify for the language of the law.
There's a pretty well-known ranch in the Wolverine Spring Branch area and an irrevocable trust because Grandpa didn't want anybody to ever sell that land. And it's been problems for the heirs because they can't afford taxes and things like that.
Yep, the taxes, once you go into a trust, tax rates on trusts can be higher because they don't get all the exemptions. So you have to be very careful with what the assets that you put in there and make sure there's enough cash producing assets to, in order to keep those bills.
I've seen irrevocable trust used prior to a bankruptcy filing. Many years ago, things transferred into the children's irrevocable trust to protect it from bankruptcy of the parents.
And you gotta be really careful if you're gonna do that.
That was many years ago, so
Yeah.
and it wasn't me.
Because you gotta make sure that there's enough time there that it's not a fraudulent transfer. You're trying to do it to avoid bankruptcy. It's probably
I've
not
always
something
wondered
I would
about
be-
that.
Probably not something I'd be comfortable doing, but I don't know enough about it to know exactly about bankruptcy. Yes, ma'am.
I heard with the client, I had a client who owned a timeshare in another state, or Hawaii specifically. What we thought would happen here in Texas with the estate, because he had a timeshare in Hawaii, he was subject to probate there, and it tied everything that he owned in Texas there. Does that sound correct?
Correct, yeah.
Okay.
So a good reason, that's a really good reason to have a revocable trust.
Got it.
Because you can put that Hawaii real estate inside your revocable trust and avoid probate in every state. So clients that have real estate in more than one state, revocable trusts are a no-brainer because not only that, but probate fees in places like Hawaii, and don't quote me on this, but I've heard the probate fee in Hawaii, or there's a probate tax that's like 6% of the state.
Yep.
And so you can get those fees eaten up really quick.
And
I
they require the
mentioned-
heirs to physically fly there to go through the process.
Yeah. And I mentioned that probate in Texas, in Bexar County, we can get through to a hearing in about 3 weeks and kind of deal with things for somewhat minimal cost. If you're in California, probate can take, even with a will, can take up to 2 years. And so it can be. I wanted to answer a question, had a question about cost. So what should somebody kind of expect to pay if they're handling the situation? So I'm going to break that down between if they were, and these are approximate costs, but if you came into our office and said, I want to do a will-based plan, or if you came into our office and said, I want to do a living revocable trust-based plan, what's the difference in cost there? So will-based plans, you're going to be looking at about $2,800. Okay. Now, what is that? That includes is the durable power of attorney, medical power of attorney, HIPAA release, declaration of guardian, directed positions, and a will, kind of all those things we talked about.
Is that the
This
7
is for-
documents you were talking about?
Yeah, basically the 7 documents, and that's for a husband and wife combined plan. That's a tradition, kind of a traditional husband and wife plan. At the first death, so when husband passes away and we have to go through probate, I always pick on husbands first. So husband dies, now you're gonna pay about $3,500 going through probate, give or take some dollars. Some are less, some are a little bit more. And then when the second spouse passes away, we go through probate all over again. So first time was to get husband's name off the real estate, off everything else, so the wife could deal with it on her own. Now she's passed away, we need to retitle all the assets to the children. We're spending about $3,500 again to go through that probate process. So upside or sideways math, that was about $9,800 there. So the living revocable trust, you're looking at closer to about $4,000 to go through creating a revocable trust. The difference here is with a trust, if we put everything in there, we avoid the probate process. And so at that first death, when the wife is coming in saying, how do I clear up everything? She's going to spend maybe 2 hours time total with an attorney to do a couple of documents, send her on her way, so she can take things to the bank to show, and the title to show she's fully in charge now. There's no going to court, no waiting 3 weeks, no amount of time trying to struggle with dealing with probate there. And then when the second spouse passes away, we would say it's about $1,000 typically. So we're at, I think, $5,500 total. So The reason is a little bit more is now we're dealing with a new trustee, maybe you name one of the kids to be trustee, and so we're having to explain the whole process to them because they've never been involved in it before. So it maybe take 3 or 4 hours of time. So at the end of the day, both of these plans are really good plans to have in place, either one or the other. Because if we looked at earlier, if we compare this to the situation we had earlier where I died without a will and had the 4 minor children and the child from the other relationship, we were looking at $20,000 in legal fees by the time we went through 4 or 5 guardianships plus an intestate probate and everything else there. So we were looking at $20,000 to $25,000 versus, at the first death versus about 6, or versus, about 5,500 even here and or 4,500 and never going through probate court. So either plan is a good plan. The only bad plan is not having one at all. So I tell people all the time, if you're not comfortable going and spending more and doing a trust-based plan right now, just do a will-based plan and get something in place that you don't struggle with. Go ahead.
Can you do both a revocable trust and a non-revocable?
Yes, you can do.
Like putting things, like you said.
So her question was, can you do both
Medicare
an irrevocable and a revocable trust? Yeah, we do that all the time for different, so we have somebody who put most of the assets here in a revocable trust, but they have things they want to set aside for the children, or they want to protect this asset for Medicaid purposes or something, so we start putting it over there. We are right at 1:28, so I have enough time for 2 more questions, and then I'm happy to stick around if you have other questions, but I want to be respectful of everybody else's time.
You talked about needing to do accounting for the revocable trust. You put your bank accounts in there, so what type of accounting is that?
So on the revocable trust, if we go back to the slide up here, we've put everything, we have everything in here in the trust, but remember, go back one more. Initially, grantors, my wife and I, are the initial grantors, we're also the trustees and we're also the beneficiaries. So we don't do any kind of fancy accounting ourselves right now. Because who's gonna complain? We're not gonna file an action to remove ourselves as trustees. But the moment that we both become incapacitated and Frost Bank steps in to be the trustee, now Frost Bank is going to have to keep good accounting records to make sure that they're taking, so that they can prove that they're taking care of them. So that accounting can be, every dollar in and every dollar out gets accounted for.
But right now, you don't have to do
But right now, we don't do any accounting because it's just us.
And then I have another question. Does the executor have to be a resident of the state of Texas? You live in Texas?
Question, does the executor have to be a resident? No, the executor does not have to be a resident. They will have to appoint a resident agent in the state of Texas. That can be their attorney who lives in, or who offices in Texas, or there are registered agents, there are agencies that will just be registered for folks there. Okay, one more question? Yes, ma'am.
If you already have a revocable trust set up and you buy like an investment property, you mentioned something about the LLC. Is it better to put it into an LLC, and would that automatically be included in your revocable trust?
So if you have a revocable trust set up and you buy an investment property, you can put the investment property directly in your trust. But if you have any liability concerns about that, like you're going to be renting it out and you're afraid you're going to get sued, then I would take that investment property, put it inside a limited liability company like an LLC first, and then have the trust own so you get both the liability protection and still avoid probate. Well, thank you guys for your attention. If you have any questions, my contact information is in your handouts and I have here. So whatever. Any questions come up, let us be a resource.
And I'll leave some of Charlie's cards over on that little area in the sales and when you guys come to the Perkin area on my little shelf there.
And Stuart Mello is our provider.
Yes.
Where's the secretary kind of book is in Sorry.
That's yours too.
Very good.
Thank you, Charlie.
Thank you.
Sorry. No, you're good. We've already signed it. Yeah. I'm gonna go figure out what name is on my license. Okay. Yes.
Yes.
Thank you.
Process would be like starting fresh.
Thank you. Right now. Yeah.
We did.
Well, yeah. So with the name of the estate planning probate guardianship.
I've heard of
Well, one of my comments was bringing someone so we avoid talking more about the state.
So we thought it was special conditions.
Oh.
Oh, this was good.
Okay.
It's still like the other one.
Okay, so, next. Now, I just submitted our information for fair housing. And so we're going to have, we're gonna bring that class in August. So let's talk to Ray about that. We'll see how we're working on it. Do the fall. We'll be put together. So we can start it. Birthday week. Write it. And we can make it a 30-minute or an hour.
I did not have my car. I know.
So that's our fall project. We'll get new classes for next year.
Yeah, he looks skinny in that picture.
He did look good in that
And.
Oh, you are welcome. You're welcome. I am a student. I promise you, I can't print your flyers. I will get you onto a site that create flyers. I got some water in the car, I can get some water for your week now. And then I've got,
But the inspection was yesterday, and I'm gonna tell them what it is.
I will send the PDF to Aaron. Okay.
No, you don't want to involve.
Okay, here's the sign-in.
That's all you really can.
So,
I'm sure I wasn't looking at it the wrong way.
That's the way I was.
And they wind up doing the same thing.
Close it before it dies.
yeah, no, let me, I work with Chris.
Okay,
And
yeah,
I've
yeah.
got something that I can do for no council, welcome sign, waters, sign-in sheets. with
Okay.
these,
We'll
okay?
figure it out next week, yeah.
But I cannot print door hangers
Yeah,
or flyers.
I can't take, they get in town, I just take one night, and so I'm actually gonna meet
It's
them.
either,
One dinner or two.
it's a title insurance.
And then I'll kind of go.
So, but I do have some waters in the car, I'll send to them, but I can get you some vegetables, some of the supplies for you. Does that sound good? Okay. I got 1:30 appointment here. Let me check and see who else is here. Are you gonna be here for okay. And if not, I'll give you a call or whatever, and we'll get together. I'm sharing. And here's me. Cause even tomorrow, maybe after, maybe we're gonna go out. Cause I get other things together for you from my office.
No, the easiest thing.
Did you find out what your real name was? Yeah. I had to do that too. I had to look too.
Well, I've been taking Elizabeth for all my life, and then one of my teachers decided that I should put my, she made me a little desk thing.
I feel like third grade, was that what you just said? That was my teacher that would, your name is spelled Sheree. Your name is Sheree. Call me Sheree. There it is. Since the third grade, I had 2 names. Not schizophrenic.
It's their responsibility.
Good, very good. Good. I'm glad everybody enjoyed it.
Oh, yeah.
So,
Guardianship
Well, the older we get, the more we really need.
well, this is just like too in a moving packet.
Yeah.
Do you have your, get your house set up, or you don't have to work? You know, just, you know, you're not, so good. I'm glad you were here.
Appreciate it.
Hi, sweetie.